Good morning or good afternoon, everyone. Thank you for joining us for this week's episode of Litigation in Light of COVID-19. This is actually episode 10, and we are so pleased that you've joined us. Two quick housekeeping announcements as we get started. The first announcement, you may have noticed that you're currently in listen-only mode. This is to cut down on the amount of background noise so that everyone can hear the presentation. Our second announcement, today's session is not for CLE credit. We do hope that you'll find the information useful and entertaining, but we do have CLE webinars. Contact us at support@fastcase.com for more information about those. And with that, we'll go ahead and get started. I'll turn this over to Michael Sander, the founder and managing director of Dr. Law.
Hi, thank you, Erin, for putting this all together, as always. And yes, this is episode 10 of our Litigation in Light of COVID-19 series. We've been doing these every week for the past 10 weeks, starting really initially when the lockdowns went first into effect. We went over court closures, different types of ways of getting information from the courts. Slowly but surely, we kind of started looking in different areas of the law. You know, COVID-19, as we all know, has affected virtually every aspect of litigation. So we kind of been going through topic by topic, talking about different areas of litigation and how COVID-19 is affecting them. So today we have a great topic. We're going to be talking about ADR, alternative dispute resolution, and in particular, we're talking about how mediation and arbitration work during COVID-19. So we have a very special guest speaker today. We actually have a mediator and arbitrator, Kirn. Kim's legal practice of, hi Kim, you there?
Hi.
Hi, great to have you. So Kim's legal practice focuses on alternative dispute resolution, which is mediated and arbitrated over 300 real estate, education, contractual, employment, and other civil disputes within U.S. arbitration and mediation and the AAA. So USANM is another arbitration group. Her 30+ years of legal career includes mega big law firms, uber small law firms, and in-house counsel. Kim is an honors graduate from University of Missouri-Columbia and University of Notre Dame Law School. She's licensed in both Missouri and Illinois. Kim is the chair of the Bar Association of Metropolitan St. Louis on the ADR committee and past chair of the Bar Association of St. Louis's Labor and Employment Committee. She and her husband enjoy biking, working with their overly active dog, Roscoe, and volunteer tutoring through firm foundations in St. Louis, Missouri. Thanks for coming on the show, Kim. I appreciate you taking the time today.
Thank you. I'm happy to be here.
So I guess I'd like to talk a bit about kind of some background on your arbitration, but I first have to ask, how's Roscoe taking COVID-19?
He loves it because we're home with him all the time. He's never been walked in as petted as frequently as he has been the last 2 months. You know, Roscoe, like a lot of you at home with your dogs, one of the things we're experiencing when we work from home is our little 4-legged doorbell. So I'm going to apologize in advance if he makes his presence known. I have him upstairs right now, but that's an issue, and that's one of the things we're actually going to talk about is when you have lawyers and clients participating virtually, some of the things that can happen. And, you know, that's one of them, external noise.
Absolutely. So to get started, I think like maybe to set the stage, maybe you can tell us just a little bit about about yourself, your background, what it's like to be an arbitrator, mediator, how you got into this field. There's most of the people who listen to the show are lawyers, are practicing attorneys. I'm sure they're all interested in kind of some of the career development aspects of becoming a mediator and arbitrator. And then happily we'll get into what's going on in particular with COVID-19.
Thanks, Michael. After practicing law for about 20 years, I really thought long and hard about whether I wanted to continue practicing. And I knew one of the things that I really loved was the personal contact, the personal connection. And I really loved disputes when I could resolve them. And I'll never forget, I had a case. I was in-house at a university as their legal counsel. And we had a case and we were in federal court. We won on summary judgment, so victory, gold medal, this is great.
Mhm.
I'm talking to the individual who had been accused of the wrongful acts. And, I was all smiles and happy and, isn't this great? And to him, it was truly the worst experience of his professional life. And while he was happy we won, it was devastating to him professionally. And he retired soon thereafter.
Mhm.
It helped me, when you're in-house, you see your clients from a different perspective and you realize the toll emotionally that litigation takes on most people, not everybody, but most people. And I had some great success as an advocate in mediations, and I saw the peace and the sort of sanguine attitude that came after a mediation versus after a litigation, winning or losing. So when I decided to, change my career completely, I had only participated in mediations or arbitrations as an advocate, but I was lucky enough to know some of the mediators at USA&M, which is based here in St. Louis, but they do cases around the country, not just here, but they were kind enough to, encourage me to learn more and to become certified. And I joined them over 10 years ago and have been slowly but surely building my practice to the point now where I am virtually full time, and that's a good thing. And I
Yeah,
love it.
terrific.
I feel like this is, becoming a mediator is more of a calling than it is
Mhm.
a career choice. I mean, you have to really want to do this because you're in competition with a lot of terrific retired judges and other
Mhm.
terrific practitioners. But I feel like, as a woman and as a strong communicator, I can bring a different skill set. And I've had some great successes. I mean, professionally, I'm having great fun.
Great. And so going kind of forward today, I mean, are you still active right now, or are there cases coming in, or are you still litigating cases or hearing cases, or what's going on right now with COVID-19 in your practice? Or actually, I'm not even sure if that's the right term to call it. If you're a mediator, that's not really your practice. It's more of your mediations.
Oh no, I'm practicing on getting better all the time.
Gotcha. Of course.
That has been one of the interesting impacts of COVID-19. Yes,
Yeah.
I have been mediating typical civil disputes, employment cases, Fair Debt Collection Practices Act, a construction case, a sexual misconduct case. So those have continued, and I've been so happy to do those virtually. But the thing that has really exploded for me has been the special ed mediations. And I work as a special ed mediator on contract with the state of Illinois and the state of Missouri. And, I think as parents are home with their children and they're doing this online learning, they're thinking, gee, Sally needs more speech therapy, or,
Mhm.
needs more occupational therapy or behavioral therapy or whatever. And they're filing claims asking for additional special ed services. And many times they're represented by lawyers, not always, but many times. And they have been really open to going to Zoom mediations. And I've been doing, I think at this point, I'm over 24
Wow.
mediations by Zoom. Zoom is really the platform that about 90% of all the mediations and arbitrations have gone to. And
Mhm.
and so that has been also a learning experience for me. I had never done a Zoom mediation 3 months ago, and now, I'm the Yoda of Zoom.
Of course. So maybe we can go on. I think you have a few slides here talking about some of the pitfalls and some of the disturbances that can come up during hearings in front of an arbitrator via Zoom. Let's go over some of these. I think this is a pretty funny one because you can see what looks like only 2% of the meeting is actual content.
Okay, this is not a scientifically based pie chart. It's funny.
Yeah, but I think, go ahead.
The message that I really want to get out to everyone is that, yes, virtual mediation and arbitration can work. It really can. Don't feel like you have to push all of your cases off until when the courts open up or when your particular county or state opens up. We can do this virtually. And I am, it's like I have been to the mountaintop, and I'm telling you, this can work. And in some ways, I have a slide later about how it can work better. So I want to quickly go through some pros and cons. I think a couple pros are it's a way for you to continue working and continue earning money, both on the plaintiff side and the defense side, because you're moving those cases. You're continuing to bill. And right now, this is where we all are. And, I'd encourage you to think of it as a way to continue to bring some money through the front door. In fact, I'm going to make a crazy suggestion and tell you, I'd ask you to consider actually virtual arbitration for some of your disputes. I mean, if you've got some cases that are some disputes that are pre-suit, of course you can mediate those, and we mediate pre-suit all the time, but you could also suggest to the other side, what about arbitrating this? That way we're not dependent on when the courts open up. I think we're all cognizant of the fact that when the courts open up, the criminal docket is going to take priority. So, in a private arbitration, you get top priority. And there are lots of different providers out there. Of course, AAA, and I mediate through AAA, but USANM is a provider. So there are different regional providers. And I'd encourage you to be cost conscious about that, because the prices vary greatly, from filing fees to arbitrator hourly fees. So, but think about that. I mean, it's a way for us to move a dispute forward in this crazy, strange time of COVID-19. I think a couple of cons for virtual mediation and arbitration, it can be clumsy. And this is a great example of that is the fact that you are not seeing me right now. I have a camera and use Zoom all the time. We're on GoToWebinar, and for some reasons my security settings were blocking this. So even though I am all ready for this, it's not working. So we're able to, it's clumsy, and you've got to be fluid and flexible and move forward with what you've got, because technology is something we have to deal with, whether you love it or hate it. Doing virtual ADR, you've got to deal with the technology. I think it also can be kind of cold, and that's one thing I've really been working hard on, is to try to warm up my Zoom mediations by chatting about, funny things that are happening or their artwork in the background. One funny thing that happened to me during a mediation is one of the lawyers was in his home office, and all of a sudden behind him we see his 7-year-old son with his pajama bottoms on and shirtless coming into the room, complaining to dad that his iPad isn't picking up the latest Power Rangers or whatever crazy thing he wanted to watch. And so that was kind of fun, as we got to meet his son. Of course, he said hi, and once he realized, that he was getting some attention, he was on dad's lap, and
Oh my gosh.
we were able to warm up that process. And in a way, I mean, it's different, of course, than being in person, but different, and it can work. Let's see.
Yep.
I think
Bring the whole family to court.
Yeah, exactly. The thing about Zoom I want to talk about is there's a free version for users. Although if you want to go longer than 40 minutes, you have to buy Zoom, but very affordable. It's $15 a month. There are even more expensive versions out there, and I know a lot of the law firms have gone on and purchased a more expensive version. But there are other platforms, and I think everybody's trying to quickly fill the vacuum that's there for how are we going to handle this. One of the biggest issues that I hear people worry about is confidentiality, and I want to hit that dead on. First of all, Zoom does have the capacity to record, but Zoom also allows your host to disable recording. And of course, in my Zoom mediations, we disable that recording device. And even if you have more distrust, if you're ever on Zoom and you try to record, you will notice that a little red movie camera icon pops up. And so you see that someone's recording. And,
right.
So you do have some good ways of checking that. I also, when I do my mediations and arbitrations, I not only, of course, have a meeting ID, but I also have a password. And then I also enable a waiting room in which you will go into a waiting room and I allow you into the mediation person by person. And that way I can confirm you are who you say you are. If someone pops up with just a telephone number, I can confirm who they are once they're in. And let's say they're not who they say they are. I can immediately kick them out of it, disable them, or remove them from the mediation. And then they are not able to come back in.
Gotcha.
Once you get kicked out, you're not able to come back in. And one case I had actually where somebody was having spotty Wi-Fi and he left and was having trouble getting back in. Well, we quickly, were able to pivot into a different Zoom session and get him in. And so there are really good ways to protect the confidentiality. My kids have had issues with Zoom trolls on their online classes, but those did not have passwords, and I think they also were pre some of the updates that Zoom has made, and Zoom has done a great job of reacting to the confidentiality issues and putting a lot of updates out there. And I, at this point now, I'm 28 mediations, arbitrations in, and I have not had, a Zoom troll in. So knocking on wood right now. It'll probably happen tomorrow, but I think confidentiality is something that we've been able to address.
A few quick questions here. I mean, there's so much to unpack with this. So just an initial question is, how did you educate yourself with Zoom and with these online meetings? Did you kind of come up with your own procedure that, we're going to use Zoom by default, or we're going to use, the lawyers get to choose what platform they want to use, or maybe does USANM or AAA, do they dictate any of these procedures, or this kind of goes arbitrator / mediator by arbitrator?
At USANM, we do have a list of sort of Zoom protocols, and we send those out to the parties in advance. I do sort of have my own as well. And one thing that I am a little bit ticklish on is whether the video is on or off, because I have parties that want to participate without the video. And, there's good and bad with that. I think, we're able to get a little more information if the video camera is on. But I also want to meet people where they are. Maybe they're not comfortable with their appearance, or maybe they're not comfortable with the background. And so, that's okay too. We've got to be, I'm really big on trying to meet the parties, meet the lawyers where they are. The thing about Zoom I like is that they have some really nice tutorials on their website, 2 or 3 minutes long. I think they're pretty easy to follow and understand. And I use those. I also, USANM did a Zoom kind of practice class for all of us. And,
Right.
I think the more you use it, the better you get at it. The more you feel comfortable with it, the more you test it out,
Yeah, absolutely. I think some of the problems that a lot of people find with the online platforms, we actually had, last week we talked about depositions, and there's a lot of confusion about exhibits and how to offer them, and kind of how to kind of bounce between documents and making sure that, you know, only the right people see the right pages from the right document. How is that typically done in the context of arbitration or mediation?
Yes, that's a great point, Michael, and I have that on the slide later.
Oh, you want? We can bounce ahead to it if you want.
Okay. Yeah, go on to the next one. Yeah.
Oh,
I'm sorry.
this
Back.
one here.
Yeah.
Here. Great.
Zoom has a share screen option. So as the host, or I can make other people co-host, I have the ability to share a screen. So what I have done in my cases is ask the lawyers to email me the documents in advance, or sometimes, you know, there's a document we didn't know we were going to talk about, but all of a sudden we are going to talk about it. So they can share it on screen if they want, but most seem to be more comfortable with emailing it to me, and then as the host, I put it up, and everybody looks at it. And I'll tell you, here's something that works better. When we have that, let's say we've reached a settlement and we're going to do a term sheet, or we're going to put the actual release itself up on the screen. I put it up on the screen. Everybody sees it in real time. You know, we're able to talk about, you know, that liquidated damages clause is no good. That's got to go. Okay, I agree. We can take that out. So they see me in real time deleting it, you know, off of the settlement agreement or off of the term sheet. And I have found actually that has worked great for, I mean, the parties sign it then and there. We all, you know, they verbally commit, okay, sign my name to it, or I can even email out. I mean, I think fluidity and flexibility is the key to this. So if they want, I can save it, email it out to everybody. They can, you know, sign it as a PDF. They can print it out, you know, and actually physically put pen to paper, scan it, and send it back. Whatever they're comfortable with. But I mean, I agree with you. I think the documents can be overwhelming. And what I did, I've done everything I have just said, in addition to a more old-fashioned way of literally taking, you know, exhibit 1, holding it up to the camera and saying, right, this is the document we are talking about. Yes, it is. Yes, it is. Okay, then we can move forward.
What I find pretty interesting about this is it seems like, you know, Zoom has been around for a while. Web screen sharing has been around for a while. We're all now being forced to use it whether we like it or not. But kind of some of the things you're describing, you know, while for many people this is a pain, adjusting to the new normal here is you know, an uphill battle. But it sounds like, you know, along the way we find some small wins, like, oh, all of a sudden all the parties can see, you know, the judge deleting a line altogether and it's crystal clear. Or, you know, everybody can all look at the same document very easily, and not really have issues, not necessarily have as many issues with kind of fumbling with paper. So, you know, there are benefits to be had here, as well as, you know, some of the stumblings with learning new technology.
I love that. You're right. Small wins. And if you go down to, I think it's slide 9, I'll talk about a couple of the things that I think actually work better. No, okay, Zoom 8, sorry.
There we go. There we go. Perfect.
Document sharing is one of them. I mean, the best thing you can do is to try to share those documents in advance. Make sure that your mediator has them in advance, and we can, you know, share them, pull them up. I tend to put most of my documents on my desktop, and that way I can open them and share them really easily. But, you know, there's also an issue with, I think, travel and travel expenses and elderly clients. I know I've mediated with clients who are in wheelchairs or clients who are elderly, a client who had big issues with elevators, and we're on the 18th floor. So, you know, so in some ways that can be a small win. And one thing that some mediators have been talking about is that they believe parties might be more comfortable if they're in their own home making those decisions. And I see that you could feel more comfortable sitting in your own home deciding, you know, about the dollar amount in your case. But I want to flip that too, because that could be a negative. You know, if you're mediating a case and you're talking about big dollars and you have, like me, adult children who are now living at home with you or a spouse, and maybe things are not all rainbows and unicorns, might be tough to
Right.
have the conversations where you can be overheard. So you want to be cognizant of that. I've heard of people going to their cars and taking Zoom calls or taking calls, or, you know, one thing I had in one case is the lawyer and the client met at the client's office in a large conference room. They sat apart in the conference room, and then they participated all day live together while the rest of us were all on Zoom. So that was a way too. You got to be flexible on this.
You know, there's actually this issue came up. We interviewed somebody who did it was a first court hearing, a video conference court hearing in Texas federal court ever, and it was just conducted a month ago or so in response to COVID-19. And when we spoke to the lawyer who conducted that case, who conducted that hearing rather, and they said there was initially, you know, this was when it was brand new, when, you know, this is the first time Texas federal courts have ever tried this. So what she said is that there was initially a proposal where the parties were in different states. And so some states were entirely locked down. There were some New York attorneys who were entirely locked down. They couldn't leave their house. And there was other states where, you know, the city was half locked down. So while the attorneys couldn't go to the courthouse, they could still go to a conference room and meet together. Have you seen that ever? And basically it was a dispute over whether, okay, well, one side of the opposing counsel is completely locked down. They can't leave their house. And the other side can actually go into a conference room and, you know, kind of converse among themselves. Obviously, there's slight advantages you can have for having everybody together. And so they started this little dispute back and forth over whether, okay, well, because our side is completely locked down, you know, your side should also do the conference from home. This issue became moot because, you know, the other side there, that city that they were in got locked down as well, so they couldn't go in either by the time the hearing came around. But have you had any of these disputes between clients kind of over the format or the placement of witnesses or anything like that in leading up to a video conference hearing?
Yes, the dispute I had was one of the parties, not the lawyer, one of the parties wanted to turn off her camera, and everyone else had their camera on. And she, you know, for whatever reason, didn't want to participate using video. And it did become an issue. And we went back and forth and back and forth. What I did, though, was we broke up and used the breakout rooms function on Zoom. And once she was in the breakout room, she was willing to turn on her video and participate with me and with her advocate. So it didn't matter so much in the end, but yes, I think that's a real issue. You start mediating, you know, the mediation. But again, you know, one of the things I think is cool is that, we're going to have this where some areas are more open than others. And if you try to do this virtually, you're able to bypass that, you know, and say, participate in the way that we can.
Right. I want to go back to actually something you said earlier, and I think this is actually especially relevant to a lot of the litigators who are probably listening in, as using mediation as a way to actually kind of increase, you know, your billable hours right now in some ways. The idea is kind of moving your civil cases from a public courthouse into a private arbitration can kind of really push things forward as far as speed goes. And so a case that's, you know, if you have a civil litigation that's going to be stalled for the next 6 months, this could be some way to get a disposition out of it. Have you seen anyone moving from, you know, from courts, federal or state or otherwise, into mediation during this time period, or has it mostly been kind of new cases that have been popping up?
No, I have seen people put in their cases. And here's, I think this is a really important point. We don't know what the new normal is going to look like.
Oh, you have actually a slide on the new normal. Let's pull that up.
So,
Here we go.
the beginning. We don't know what the new normal is going to look like. And what we're looking at right now, or what we're considering, is when we do get together in person, for an in-person mediation or arbitration, we're going to be wearing masks.
Right.
So if you believe that it's super important, for this mediation to take place in person, for that nonverbal communication, for all the good things you get in person, and believe me, I prefer in person too. But how much information are you really going to get from a person wearing a mask the whole time versus being able to do this via Zoom and being able to see their whole face, their whole body,
Right.
thing with breaks? I think because the new normal is still in flux, I'd rather do a Zoom mediation than I would a mediation wearing masks or an arbitration wearing masks.
Right. Right. Absolutely. You can definitely get a lot more done. I have another question kind of related a little bit to just the differences here between in-person and a video. I'm not actually, in my past, I was a litigator. I know kind of how federal court procedure works and some state court procedures work. I have not done arbitration. Is it typical to have court reporters in arbitrations? Is it kind of something that both sides can agree to, or is that atypical? And if you do have court reporters, how does that work with Zoom?
Sure. I would say most arbitrations do not have court reporters. However, if the parties want to have a court reporter and they're willing to front that expense, many times we will have court reporters. The arbitration cases I have done during COVID-19, we did not have a court reporter. And the thing I always try to point out to the parties is, yes, you can pay for a court reporter, but your ability to appeal an arbitration is so dramatically limited. Why are you willing to pay, or give me your reasons, I guess, for why you want a court reporter? And sometimes they do because they'll have a serial plaintiff who sued them over and over and over again. And so they want that testimony. They want that decision. They want to be able to use it later. So I understand that. But they would, so a Zoom arbitration with a court reporter would be the exact same thing as a court reporter at a deposition. They'd be participating that way. I think the arbitrations can be maybe less of a leap for most lawyers, because almost all of the arbitrations I've done have included witnesses who participate either by phone or by video. I even had a case one time where the claimant's sister was a witness, and she lived in Africa. So
right.
She was a State Department officer in Namibia or something crazy. So she had to get up in the middle of the night and testify at our hearing, but she did it by phone or by FaceTime, I think. And so we're used to that in the arbitration mode a lot more than we are in the arbitration mode.
I got one more question. We're actually coming up on a half an hour here. So I wanted to open it up for questions. But before I get there, I kind of wanted to ask just kind of more of overall, like if you're a litigator and you have, 5-10 cases pending in court and they're all kind of stalled, what do you recommend? You have to kind of strategically, mediation can move things faster, make things go more quickly. So you might not want them, depending if you're on defense, you might not want them to go a little bit, want them to move forward as quickly as possible. But kind of what's your, how would a litigator go about moving this into mediation? Is this something that they would kind of talk to the other side, the opposing counsel with, and see if they were open to it? Would they talk to the judge to try to get the judge to push things into mediation? Would they file a motion to force the judge to push it into mediation? What's the procedure of kind of moving a case from a court into a mediation or arbitration?
It varies so much between court to court. There are some courts that mandate mediation. The federal court here in St. Louis pushes every case to mediation. I mean, it is a standing order. You will go to mediation, and they give you a deadline. Other courts, it's optional between the parties.
Got it.
One thing that I've heard a lot is one lawyer will say, I'd love to mediate this case, but if I suggest mediation, the other side is going to smell blood and know that week and that I want to settle and, you know, take advantage. And I actually write a blog called Mediation Under the Arch, and I address the issue in my blog because there are some ways around it. And I think, you know, you can make it clear to the other, you can still suggest mediation, but say to the other side, you know, I've had Judge Smith before, or whoever your trial judge is, and I know she likes mediation. I think, you know, she would encourage us to mediate this. Why don't we just do it now rather than waiting for the judge to, oh, well, thank you, there you go, you have it up.
Hold it up, just so people can take a look. Mediation on the Arch.
Yeah, I try to make it very hands-on and very kind of fun to read. As you can see from my slides, I like to try to bring a little levity to the situation because so many times the disputes we're dealing with are so very serious and so very, you know, heartbreaking that it's nice to use some humor in the when appropriate. You know, that's the key, is when appropriate. But there are ways that you can look at your cases and assess which one is ripe, you know, for mediation. And I think what we're all realizing is that the pressure of having a trial is gone. You know, there are no trials that are going to quickly. So how can we move those cases forward, and what are the best ones to do? You know, usually it's best if you have had the plaintiff's deposition, I think. It's always nice if you've been able to narrow down the issues through either motions to dismiss or motions for summary judgment. And those can go forward even under COVID-19. But you know what? I say that, but yet I mediate a good number of cases pre-suit. Probably a third, maybe 20% of cases are pre-suit. And I love those cases because we don't have the big dagger of attorney's fees hanging over everybody's head the way you do when, you know, you're $50,000, $100,000 in on attorney's fees.
Absolutely. Definitely different levels of pressure. I think before we get to, I'll give you some time to have some closing remarks. But Erin, if there are any questions, be happy. This would probably be a good time to take them.
We do have a couple of questions. The first question that I'd like to join us with is there a change in the cost for mediation when it's done online, or should there be?
No change in cost so far. I do think that's a legitimate point, and we might want to look into that. One thing that USANM offers, and I know some other guys offer too, are flat fee cases. And at USANM, and I've done some of these, if the dispute, if the last demand is under 75,000, we'll mediate it for a flat fee and then a lower hourly rate if it goes beyond the 2 hours. So right now, no change in mediation fees, but I think that's a good question.
Great. So the second question was regarding breakout sessions. How does someone who's participating in a mediation feel comfortable that another side can't hear in a breakout session, or how do you recommend testing to ensure that that is not happening?
Yeah, I think that that is a real concern. And what I have done, two things I have done. First of all, if someone's uncomfortable, do a practice session, maybe the week before the mediation. Practice the camera, practice the microphone, the lighting, the dress. You know, the slide I had earlier about, oh my God, does my neck really look like that? So you're practicing, you know, not falling off your chair when you see what you look like on a video. So a practice session can help, and we can set up those breakout rooms and you can see exactly how they work. You know, I can move myself in and out of the room, and I have done that, and I think that's a great way, especially for the lawyers, to feel more confident. Another thing that I try to do is when we're in the mediation itself, to use the breakout rooms and to kind of almost prove to the parties and the lawyers that indeed when I'm in with the other side, they cannot hear me. They cannot, eavesdrop. There is a chat function that Zoom has. There are two functions. One's called chat and one is called broadcast. And as the mediator, I'm able to broadcast to everyone or to a particular room, what's happening. And sometimes I'll broadcast. Looks like we're at impasse. I'll be rejoining defendant's room in 5 minutes or something like that. But the chat function is nice because you can chat privately or you can chat to everyone. I use it. Most of the time the parties don't use it for that very reason. I'm worried about confidentiality, and I get that. So what I have encouraged people to do is, and believe me, this has happened, send text messages. So I'll get a text message from one side in the middle of a Zoom mediation, asking me to come back or asking me what's going on or something, as well as email. So we are floating between all these different methods of communication, and I think it's great. I mean, let's use all the technology we have at our fingertips to try to find a resolution and to make people, as comfortable with this process as possible. And I have done all of those, and if they work, it's great.
All right. Speaking of tech questions, one of the questions we had, do you recommend using 2 cameras, one to display documents, as well as using 2 monitors to be able to see both the document and the Zoom attendees?
I do think that's really nice, especially if you have documents with small print or a case that is document heavy. I think that's quite nice.
Excellent. One more tech question. There's a number of different platforms out there. Zoom and GoToMeeting are 2 examples. How do you get people comfortable with your chosen platform?
2 ways. I offer to do a practice session with them, and I've done that. And we'll play around with, what this button does, what that button means. And I don't charge for that. And I try to do, maybe a 15-minute practice session. And then, when we get into the actual mediation itself, just slowing down a little bit at the beginning so that I can see how tech savvy people are. And really, the issue that I've had that has come up more than anything has been bandwidth. And, if I have a client that's participating from a rural area, they're at home and they live maybe out, not in the city or something, and they don't have good Wi-Fi, trying to figure out how to do that. And one of the things that Zoom offers is people can call in, so they're not on by video, but they can call in and they can still hear everything, they can still speak, but they're not participating by video. That uses a lot less bandwidth, and that's a great tool for us to use. I've also had parties where we'll be on the Zoom call, but the lawyer will break from Zoom. The lawyer will go actually call the client on the phone and, have a telephone conversation, which is exactly what we did pre-COVID-19 when we had an insurance adjuster, from another part of the country who wasn't there in person but was participating. So that's no different, right?
Makes sense. One last question, and then I'll get you guys to your final remarks. The final question was regarding some of the formalities. A 2-part question. First part, how do you swear in a witness in arbitration using Zoom or another virtual product? And then the second question was, there appears to be a trend towards treating these meetings with less formality. Can you comment on that trend? Do you feel that it should be formalized somehow?
I tend to fall on the less formal side. I like to use first names. I like to bring, as I said earlier, some levity into the situation when appropriate. And so maybe I'm not a good person to answer that question because I like a less formal mediation. Arbitration is different, and that tends to be more formal. I have sworn in the witnesses myself using Zoom, and everybody sees it, everyone hears it, and we've moved forward that way. Did I get all the questions? Did I answer?
Yes, you did. That's excellent. Thank you.
Great. So if, I'm not sure if you have anything, I mean, we covered quite a bit today. Kim, thank you so much for coming on. I think I actually learned quite a bit about mediation and arbitration. Like I said, I have experience in courts and not so much with alternative dispute resolution. But I'm personally pretty impressed to hear just how open to innovation and open to change. I mean, as a legal technology innovator myself, it's really refreshing to hear that some of these courts are, I'm sorry, not courts, that alternative dispute resolution mediations are actually embracing these technologies and kind of moving things forward at a much faster pace than we would otherwise get from the courts. And also might even provide a model for some of the courts that eventually follow when they do start to reopen. So this has all been very impressive. Do you want to have any closing remarks with respect to your practice or what's going on with COVID-19?
Well, everybody stay healthy. Thanks for having me on. I have really, I mean, it has been a huge change for my practice, but I think in a good way. I'm kind of proud of myself. I wouldn't, when I started practicing law, we did not have computers. My secretary didn't have a computer. I didn't have a computer. Lexis was to be reserved for only those very high-paying clients. I mean, it was crazy back then. So I'm really proud of myself, I guess, for mastering this. And I think the message I'd want to give everybody is really this can work. I am so thrilled with the results I've had, and I know the lawyers have been happy with the results. And we don't know when this gets back to normal and even what the new normal looks like. So lawyers are slow adapters. I put myself in that category, and yet we are being forced to move in this way, and let's embrace it. Let's do it.
Absolutely. All right, I think that's a great way to end it. I thank everybody for joining this call today, the Litigation COVID-19 series. Please enjoy the long holiday weekend. I know we could all use a little bit of time off. We're all working even harder now, given there's no working hours really anymore. So please take the day off and enjoy it, and stay healthy, everybody. Thank you again, Kim, and thank you all for joining us today.
Yes,
and
thank
Erin,
you everyone
very
for
much.
joining us. And we will have a webinar this following Friday. We're going to be talking about COVID-19 and using the FastCase platform. So keep an eye on your email for an update on that.
Excellent. All right, thanks so much. Bye-bye now.